Okay, so hello everyone, and welcome to this webinar on GDPR after Brexit. And we're going to be focusing on EU representatives and what that might mean for you as a company. So just a bit of background on who we've got speaking today. I'm Charlie. I'm a privacy and GDPR compliance specialist working for Predetect, and I've got a wide range of industry experience in international markets, from America all the way to various European places. And I'm joined today by Rob. If you'd want to introduce yourself a little bit, Rob.
Indeed. Thanks very much, Charlie. Much appreciated. Very much pleasure to have the opportunity to speak today. My name is Rob Masson. I am CEO of the DPO Centre. The DPO Centre is UK's Data Protection Officer Resource Centre. So we have one of the largest teams of data protection officers located throughout the UK, who we place into organisations on either a kind of ad hoc consultancy or interim basis, or as part of an ongoing arrangement where we act as the organisation's designated data protection officer on what we call a fractional basis. So that's generally anything between 1 and 8 days per month. DPO has been around for the last 4 years. In that time, we've worked with over 350 different clients from a range of industry sectors. We have particular strength in things like health and financial services.
Okay, that's great. Thank you for joining. We really appreciate it.
Pleasure.
So I think we should do a bit of background. So Rob, would you like to give us a bit of information on how this has happened and why we're doing this webinar today?
Yeah, sure. No. So in terms of a bit of background, as I'm sure everyone knows, based on the referendum that the UK held in 2016, the UK formally departed the EU on the 31st of January this year. So we're now in the remaining 7 weeks of the transition period leading up to exit day. Now, UK Prime Minister Boris Johnson made it clear that he wants to get Brexit done. So there's currently no signs that cut-off date is going to be extended. So the UK's exit should complete automatically at 11 p.m. UK time, so midnight European time, on the 31st of December 2020, so literally 7 weeks' time. But up until that point, it essentially continues to be business as usual. Now, the UK has adopted many of the EU laws as UK laws, which means that one of these is the EU GDPR. So initially, at least, we've got both the EU and the UK GDPR. Now, they should remain identical. However, they are likely to diverge over time, which is most likely going to add complexity to the challenges if you're processing personal data on both EU and UK residents. And in the case of something like a significant breach or a compliance failure, it also creates the possibility of investigations and fines from both the EU and UK supervisory authorities.
Yeah, definitely. Okay, so we'll go on to the agenda here, just so we'll run you through what we're going to be talking through. So we're going to start off with ensuring everyone's ready. So that'll be how Brexit is going to affect your company's day-to-day processing activities. Then move on to what Rob was talking about with the UK data protection law combined with the EU GDPR and how that adaptation is going to occur. And then on to the representatives, what a representative is, do you need one, what is their role, etc. And we'll wrap it up with a quick Brexit transition checklist so you can go through and see exactly what you need to be prepared for 2021. And now Rob's going to be going into the what we can expect aspect.
Okay, so the key message really is that like any other country that is outside of the EU, the UK is going to become what is known as a third country in respect of EU GDPR after exit day, so from January the 1st. Now, how much of an issue this is going to be is going to depend greatly on what is called an adequacy decision. So adequacy decisions are made by the European Commission. It's based upon what's set out in Article 45 of the GDPR. And traditionally, these decisions have taken around 18 months to complete. Now, the assessment is there to confirm that similar protections are offered to EU data subjects as they are provided under the GDPR. So where a country is deemed to be adequate, personal data can flow freely between the two countries and without the requirement to implement additional safeguards and controls. Now, adequacy decisions are a two-way street. So the UK must consider the EU adequate and vice versa. Now, the UK has already confirmed that it considers the EU to be adequate, along with the 12 other countries that the EU also considers to be adequate. And then back the other way, 11 of those 12 have already stated that they consider the UK to be adequate, with the only exceptions thus far being Andorra. But fundamentally, it's the EU does not yet consider the UK to be adequate. So now officially, at least, the Commission's review of the UK was not started until the 1st of February, so after Brexit was essentially completed. And the UK is apparently still the 13th in the queue. Now, it also means, it's by no means guaranteed that a positive decision will be granted as part of the Brexit negotiations. I think a lot of people are assuming that's going to be the case. And that's especially not the case in the light of the recent CJEU ruling that deemed the mass surveillance laws of the UK and a number of the other EU member states to be in breach of the fundamental privacy rights of EU citizens. So with this being the case, it would seem, on paper at least, that a positive adequacy decision in respect to the UK is unachievable. Now, if that proves to be the case, then an exercise of implementing additional safeguards is going to be required with each of your suppliers and your partners and your vendors and your cloud service providers, et cetera, et cetera. Now, there's most likely going to be in the form of what are called standard contractual clauses, so SCCs. And therefore, given that we are now literally only weeks from exit day, it's a kind of a data mapping exercise to ascertain what are called your cross-border personal data transfers. Should be, hopefully, somewhere near the top of your kind of Brexit to-do list. And to many, kind of the absence of an adequacy agreement prior to exit day seems inconceivable. I mean, considering the economic benefits it brings to both parties. However, there really are no positive signs emerging that it's actually going to happen. So we may therefore be heading for some kind of partial adequacy arrangement. And it's kind of a personal opinion in a way, this one, but it's where data flows for kind of specific circumstances can continue, but others are going to require the implementation of additional safeguards in order to be able to continue.
Yeah, I think that was really well put there. I definitely agree with you on the partial adequacy, at least initially, while they're figuring out the rest of the decision. So with that in mind, and we've discussed the SCCs a little bit there, we'll go on to how does this actually impact the international data transfers. And what it means is that the data transferred from the EU to the UK will have to abide by local requirements. But also there's a concern, and I'll be interested to hear your opinion on this, Rob, about the data potentially being trapped in the EU. So that would be because the processor SCCs don't exist, right? Do you?
Yes, it's processor back to controller. So at the moment you've got processor to controller to processor and processor, but you don't have processor back to controller. So the UK is adequate, considers the EU adequate, so you can transfer it freely to the EU. But then if the EU doesn't consider the UK adequate, then it puts a potential block in the transfer back again. So it's one of those quirks that we're going to have to kind of work out exactly how we're going to cover it.
Yeah, and that's something we'll have to figure out when the time comes, I guess. because at the moment it's unknown. And as you can see here on the slide, there are some scenarios here. So if you're a UK-based company and you're solely processing personal data in the UK, you really don't need to worry about these changes too much. But then, as Rob mentioned, if you're using a cloud service outside the UK, which in this day and age, that pretty much covers most companies, I would say. So you will need to act accordingly and take all these things into consideration. And some simple steps we've got here, we'll get into them a little bit more, are to obviously use these standard contractual clauses and get an EU representative. But in my opinion, I think it's about being prepared. This transition is going to be very big, and it's going to impact all different types of businesses. So being prepared is of the utmost importance.
So I think, I mean, the big issue in terms of international transfers is I guess the Schrems 2 case from the decision that was made back in July. For those that don't know about the Schrems 2, it's basically a case between Austrian privacy activist Max Schrems, and it's been a very long run. It's about 5 years it's been going on. So it's between Max Schrems, Facebook, and the Irish Data Protection Commission. And what's happened is the ruling made by the Court of Justice of the European Union, so the CJEU, was to invalidate a mechanism called Privacy Shield, which was there to enable transfers of personal data between the EU and the US. Now, it was a Privacy Shield was like a self-certification scheme that US organisations can enter into. And it provides a framework by which they enable transfers back and forth to be compliant with EU data protection requirements. Now, at the same time, what happened was various legal manoeuvres by Facebook essentially meant that the CJEU also had to end up calling into question the much more widely used global transfer mechanism called standard contractual clauses. So these are clauses that you insert into contracts with each of your vendors and partners, and it's the terms by which you will abide in respect of transferring data. Now, thankfully, the court did not entirely invalidate standard contractual clauses. However, they did rule that additional measures would now be required to ensure that transfers were not subject to mass surveillance laws of foreign governments. And part of the problem was that the decision came with no grace period and no obvious alternative solution. So even now, we still don't have an exact kind of solution to it. And what the spotlight is on the US, simply because most of our data ends up in the US, but it's because of an act called the Foreign Intelligence Surveillance Act, so FISA, and also actually a specific executive order that was signed when Ronald Reagan was president back in 1981. And it's these two kind of pieces of legislation that caused the problem. Now, as Charlie mentioned a minute ago, the spanner in the works for all of us is that the world now runs in the cloud. And the cloud, in the West at least, is dominated by three big cloud service providers, being Amazon's AWS, Microsoft Azure, Google Cloud, alongside a whole bunch of software as a service platforms, Microsoft 365, Oracle, SAP, Salesforce, HubSpot, all the big boys that are storing data. Therefore, what it means is that the vast majority of the EU's personal data, and I'm sure much of the data that you're responsible for processing, is stored within these systems. Now, EU and UK organisations have quite rightly configured their tenants inside these platforms to physically locate their data within the EU or the UK. But the problem is, if you look at the terms and conditions of the providers, there are still possibilities for them to be able to transfer data back to the US, and therefore, just because you've positioned it in the UK doesn't mean that it's not accessible to the US. There's encryption and anonymization kind of techniques you can put in place, but they are really difficult to put in, especially kind of from an enterprise-wide perspective. So Now, it is of course possible that after exit day, the UK enters into kind of a privacy shield arrangement specifically with the US directly. However, what all that's going to do is to create even a further negative impact when it comes to the European Commission's adequacy decision, because it could mean that the UK ends up as a kind of data conduit with the US. So you transfer it out of Europe into the UK if we're adequate, and then of course you use the UK privacy shield, if you like, to transfer it to the US. So lots of problems being caused by that particular case, and the solutions haven't yet necessarily fully presented themselves.
Yeah, the ramifications are definitely ongoing for Schrems. I think we'll definitely be hearing more from him next year as well, I would imagine.
Once Brexit's complete, I suspect he might turn his attention to us in the UK.
Oh, in terms of this, what you've been discussing?
Well, I mean, yeah. Bottom line is we've got a situation where the UK's mass surveillance laws are one of the most significant globally, and therefore the decision by the CJEU in terms of both FCCs and in terms of the decision recently about whether governments are able to have such strict electronic surveillance laws. It just means that it's even more of a problem, for us to get adequacy as a result. And therefore, if we are given adequacy, then and it's all based upon all these things where it seems impossible that we would ever get it in the first place, it simply means that the likes of Schrems or other NGOs, will most likely be turning their attention to the UK. And we've got recent things going on in Belgium where now independent organisations can bring actions under GDPR and so on, which we can't do in the UK because the Data Protection Act doesn't permit it. But we're now getting these other member states where that becomes possible, and therefore it's not just regulators that are going to come after organisations. It's going to be independent bodies like NOIB, which is Max Schrems' non-profit organisation.
Yeah, it's going to be an interesting year coming up, I think, in terms of data protection, that's for sure. So here on the next slide, we're going to talk about standard contractual clauses a little bit. We've mentioned them a couple times already. And do you want to give a quick background on what a SCC is, Rob, or shall I dive in?
Yeah, so I mean, standard contractual clauses are a bunch of legal clauses that the EU actually published. I think it's back in '98. So it's not even based on GDPR. They're based on the previous regulation legislation. And what they are, it's kind of a set of it's an agreement that two organisations enter into where for transferring data. So it's the obligations that each party are going to be bound by when transferring personal data. And what it means is that personal data can then be transferred to a country that is not deemed adequate, because the individual transfers between those two organisations are then bound by the SCCs, not bound by a country-wide or state-wide kind of agreement with the EU.
Okay, yeah, that's great, thank you. Also, I forgot to mention, everyone, you can submit questions during the webinar and we'll be answering some at the end. So you should have something in the webinar software where you can just type something in if you have a query. So on this slide, we can see a couple of different scenarios here. So we've got at the top the location in the EU, and then how that would relate to a UK organization. So if it's just on the far right, if it's an individual for your own purposes, obviously we wouldn't be needing those SCCs. You wouldn't have to comply with the GDPR. If it's a data subject whose individual, the personal data is, they're the subject, you wouldn't need the SCCs, but you would obviously still need to comply with EU GDPR. And then, because it's coming from Europe, and then with the companies, with a multinational corporate group, you might not be able to use SCCs. You might have to use BCRs, which are binding corporate rules. Would you like to do a bit of background on that too, Rob? Because this is a bit less common.
Binding corporate rules are definitely less common. They're generally used for intra-company transfers. So think global corporation with a central payroll function. So what happens is, obviously, lots of personal data in terms of payroll is being transferred to a central location where processing of payroll occurs globally. And of course, you need to be able to transfer that data based upon certain rules, because obviously not every country that you're going to be involving is going to be adequate. And so BCRs, or binding corporate rules, are put in place. They're like SCCs in a way, but they can be amended to suit the organisation, but they have to be approved by one of the EU regulators in order to confirm that they comply and they introduce appropriate and sufficient safeguards for the data. Now, BCRs are extremely expensive to put in place and extremely time-consuming to put in place, and therefore they are generally limited to only the largest of organisations that have that kind of global intra-company kind of requirement. So, in most cases, most SMEs, small to medium companies, won't be BCRs are not relevant at all. I mean, I think generally it's about £25,000 exercise before you start, just in the legal fees. So, you know, it takes a couple of years, and it has to be signed off by the European Data Protection Board. So, you know, it's a very arduous, tortuous, expensive process to put them in place, and therefore it's reserved only for the largest of organisations generally.
Yeah, so that'll be conglomerates and things like that. And then here on the left, we've got the separate business or organizations, and this depends if you're the controller or if they're not the controller. So if the EU organization is the controller, they'll want to implement the SCCs, controller to controller, controller to processor. If they're not the controller, the SCCs won't be applicable, and that will require further review. So what kind of further review would that mean, Rob? Because I know there's been a lot of discussion. You'd have to look into all of your data transfers and things like that. But do you have any other thoughts on that?
I mean, this whole process is extremely time consuming. I think that the key takeaway is that in order to work out which of those boxes apply, you have to understand your data, and the step to doing that is a data mapping exercise. So that you can understand, you know, what data has been transferred, you know, to who has access to it, you know, who's it shared with, and so on. So, and then and only then can you make the right decisions about, you know, what are the appropriate safeguards to kind of put in place. Now, without doubt, in a lot of cases, SCCs, in the absence of an adequacy decision, SCCs are likely to be the way to go. But the max SREM, or the SREMS 2 decision, means that it's not just a question of, you know, slap SCCs into your contract, job done, move on. You've got to assess the organisation that you're sharing the data with to make sure that you know, appropriate safeguards are being put in place for the data at their end. And so it's not quite as straightforward. It's not quite as simple as doing so. And you know, and so there's a lot of complexities involved in doing it. And also, you don't necessarily always have the time or the leverage with the various processors that you might be working with, or partners that you might be working with, and therefore, you know, they may not agree to any kind of amendment to the contract or any change. And so, you know, you're going to have to in order to be able to lawfully transfer data. But all of these kind of pitfalls are kind of stand in the way of getting these things organised, especially given we've only got 7 weeks left.
Yeah, and it obviously, as you've been saying, these are all lengthy processes with a lot of due diligence involved, looking at your data, looking at your partners, suppliers, etc. And 7 weeks is not a lot of time, so people need to be prepared. Now, here we're going to look at the EU representatives. You want to get into this, Rob?
Yeah, so a bit of background really on representatives. It's Article 27 of the GDPR that deals with the need to appoint a representative. And it's a requirement for organisations that are based outside of the EEA, so that's the European Economic Area, but have no presence inside the European Economic Area. So it's the EU plus the extra 4 states. I think it's Norway, Liechtenstein, Iceland, and one other, I can't remember it. But it's where you're offering goods or services or monitoring behaviour. So if you're doing any of that to EEA residents, then you're going to need to appoint a representative. And the important thing is it's irrespective of adequacy. So it's not something that goes away if we get adequacy. whether we get it or we don't, the requirement, the Article 27 requirement kind of remains. Now, you are exempt if you are a public authority or body. Also, if your processing is only occasional, so doesn't present a risk to data subject rights and freedoms, and doesn't include any special categories of data or criminal records. So special categories, things like health data, race, religion, sexual orientation, all those kind of things that the really personal data that is considered under what's called Article 9 of the GDPR. So as long as you're not doing any of that and it's only occasional, then there's a potential that you will be exempt from doing so. But without doubt, a very large number of organisations will fall within that definition, and therefore, in order to remain compliant with the EU GDPR, then you are going to need to appoint a representative in time for the 1st of January. Now, the role of the representative is very different to that of a DPO. So a DPO is there to, they're required to act kind of independently within an organisation, whereas a representative acts under what's called a written mandate. So the organisation basically stipulates how their representative, or how they would like their representative to act on their behalf. Now, there are some basic duties that they must perform, and that is really to what the representative is there is to facilitate communication between EU data subjects and your organisation. So if you're processing data on a residence inside the EU and they've got a problem with the way that you're processing, or a regulator's got a problem with the way that you're processing EU resident data, then they can take that up with your representative, who then communicates back to you as the controller or processor. And so they're required to cooperate where necessary with inquiries from supervisory authorities, and they have to maintain an up-to-date copy of what's called your records of processing activities. So that might be something that's unfamiliar to organisations of less than 250 employees, because generally it's not required until you get to that size. But if under Article 30, it defines what ROPA, as we call it, records processing activities, is there to do. But when you're appointing a representative, they need to understand and have access to what you're doing in terms of your processing, and therefore you do that by creating your records processing activities and they maintain that for you on an ongoing basis, so that they've at least got an indication, a reasonable definition of what you're doing with data that involves EU residents. And then your representative's address, local telephone number, and email contact details will be published in your EU-facing privacy policy. And they act then as you're publishing them as your point of contact if necessary. So one of the requirements on your representative is that they must be established in a member state relevant to the data being processed. So if the personal data you process involves data subjects from, say, kind of France, Germany, and Italy only, then your decision as to who to appoint as your representative will need to be based on if they have the appropriate establishment in one of those member states. So you can't, for example, be processing data in France, Italy, and Germany, and then appoint your representative in Ireland. Okay, it has to be in one of those three. Now, if you're processing data across Europe, you've got some in pretty much every member state, then you can choose whatever member state you like to put your representative in. Now, whilst it remains untested, Article 27, paragraph 5, and the final line of recital 80 indicates that representatives might be adopting potential liabilities for your processing activity, so you as the controller or processor. So they're likely to require you to agree to specific indemnities with any agreement they ask you to enter into. And that means that if they are ever pursued by a regulator, for a fine that you've chosen not to pay, then they can pass it down the road to you, hopefully through the indemnity that that contract provides. Now, if your representative doesn't ask you to do this, then it may be that they don't fully understand the obligations that are put upon them as a representative, and maybe you should consider looking for an alternative in that particular situation. So given that the requirement to appoint a representative is based upon Article 27 of the GDPR, and given that from the 1st of January, there's going to be the EU GDPR and a UK GDPR, both with an identical Article 27, it means that UK organisations who are processing data on EU residents will require an EU representative. So if you're in the UK, you're processing EU data, you're going to need an EU representative. And EU organisations who are processing data on UK residents are going to need a UK representative. And organisations based outside of the EU who are processing data on both EU and UK residents are going to require both an EU and a UK representative. So there's lots of kind of bit of red tape, really, just that's being created that everyone's going to need to comply with.
Yeah, there's a lot of moving parts there for sure. And I think something that's important to mention here is that the use of the word representative makes people think that you have one person in Ireland or one person in Italy, right? But it can be an organization, right?
I mean, it's generally an organisation that would provide the service to you. I mean, if you've got an establishment in the EU, so you've got an office in the UK and an office in Germany, then that office is effectively your representative. So you don't need one. Yeah, it's only where you don't have that presence in the EU and you are processing data on EU residents that you potentially are going to need to appoint one. But generally, you'd go to an organisation because of the liabilities are very significant, the responsibilities are very high, the expectations from the regulators is going to be significant in terms of the responses that the representative is going to be required to give. It's not something you can just, kind of, oh, I've got a mate in Germany, he'll do it for me. It doesn't quite work like that. It has to be, really quite professional and established organisation that understands data protection and can advise you accordingly when certain situations arise.
Exactly. Okay, so now we're going to go on to the penalties and risks, the bit no one likes. So obviously, we know that the GDPR breaches can and do happen often, and these can turn into fines up to the hundreds of millions, depending on, it'll be 20 million or 4%, whichever's larger. And so who are the regulatory bodies we'd have to respond to? Obviously in the EU, that's the EDPB, the Data Protection Board of Europe, and also the individual data protection authorities of each individual country, which for the UK would be the ICO, Information Commissioner's Office. And you've got to think beyond the penalty. The failure to achieve this compliance has some other consequences. So think about things like reputational damage. If you get fined, that's definitely going to be in the newspaper. It will limit your capability to work in certain areas. And as a kind of abstract note, it also reduces your earning potential because you're choosing to exclude huge markets of customers who will have no choice but to go elsewhere if you aren't allowed to sell to them. So do you have anything to add on the penalties and risks, Rob?
Yeah, I mean, the UK perspective really from the ICO is, I think generally they've remained a kind of pragmatic organisation and one that focuses on promoting best practice rather than kind of wielding the big stick. Now, obviously, literally this week we've had the outcome of the significant fine on Marriott, and of course previous to that we had BA. Now, originally, pre-COVID, they were all 183 million and 99 million, respectively, in terms of Marriott, 99. And they've since negotiated that, partly, I'm sure, because of the effects on the travel industry due to COVID, but also some statements and actions they've made as organisations. They've been reduced. So I think BA went from 83 million to 20 million, and then Marriott went from 99 million to 18.4 million. And so significant reductions, but still, of course, significant numbers compared to obviously the previous legislation, which was the maximum of $500,000. So, I mean, I think from my side, from what we see in terms of clients, in a way, I would hope that the ICO were to take a bit more of a stance on the mid-sized organisations. I think that's where a lot of the processing is occurring, and they could do with a few to chivvy some people up to take some action. But to be fair to the ICO, there's 600 staff. It's 5.9 million businesses they are presiding over. You've got the likes of Facebook and Google and the ad tech industry in general tying them up in knots. With from a legal perspective, so they've definitely got their work cut out. And we've got Elizabeth Denham, who's the current commissioner of the ICO at the moment. She apparently is her tenure is coming to an end in July 21. So we might see a shift in the rhetoric and maybe a change in the kind of the action at kind of that point. But I think generally they're looking to remain pragmatic and solution finding, helpful, kind of advisory, so that generally everyone tries to do the right thing. And if that's the case, then I think generally it's quite a positive perception of them.
Yeah, I think they'll have to show that kind of pragmatic approach when trying to apply the UK GDPR, and people may be breaching the EU. Obviously, that'll be covered by Europe, but everyone, I think all the eyes will be on the UK and the ICO to see how they're going to handle this.
Yeah, and vice versa as well. I mean, I think obviously now that we've got EU GDPR and UK GDPR, you've got the potential to be fined essentially twice. So that you could have double penalties because if you have a compliance failure that involves EU residents, then one or more of the EU authorities are going to start asking questions. And likewise, if you're based in the UK and you've got obviously UK residents, then the ICO is also going to be interested. And potentially it could lead to multiple fines from multiple authorities. And that's partly down, or mostly down to the fact that because of Brexit, we're losing this thing called the one-stop shop. And it was a mechanism that was introduced a while back when it was the Article 29 Working Party, which has now become the European Data Protection Board. And what it means is that if you have a problem, you can nominate a lead authority, and generally only that one lead authority you will have to enter into discussions with and investigations from. But of course, with the loss of the one-stop shop, if the data breach or the compliance failure that you have involves EU residents, then of course you're going to get inquiries from either the main or multiple authorities.
Yeah, so ensuring compliance is even more important than ever, I guess, is the takeaway from that, right?
Absolutely, yeah.
Absolutely.
I mean, I think one-stop shop only really affects the larger organisations that are processing data across Europe, and the complexity comes from if you've got offices throughout Europe, but your head office is in the UK, then obviously under the one-stop shop you'd appoint the ICO as your lead authority because your main establishment is in the UK, and to a degree most of your processing decisions will be made in the UK. But of course, now that the UK is out of the picture, you've got to decide which of the remaining offices you've got across Europe is the main establishment in terms of processing activities, but also whether you can demonstrate whether processing decisions are being made in that office, because it might be that's where the second most amount of data is being processed, second to the UK, but are processing decisions effectively still being made in the UK, in which case you can't nominate that particular office as your one-stop shop lead authority. So for the larger organisations, I mean, a lot of the ones we work with, it's quite a difficult decision to arrive at, and there's quite some justification that's required in order to demonstrate that you've made the right decision in that respect.
Yeah, definitely. So, and that would have to be documented, I guess, how you came to that conclusion.
Yeah, and signed off basically. So you've got to essentially register your Berlin office or whatever with one of the numerous German authorities.
Mm-hmm. Okay, that's great. So here we have the checklist. Do you want to run us through this, Rob? Maybe give us a little background on each thing, why it's important, that kind of thing.
Yeah, a very quick run through, really. I mean, as I've said a couple of times now, I mean, I think start by mapping your data flows. Understand who the data comes from, who you transfer it to, who has access to it, or who you share it with. You can't really do anything in terms of understanding what you need to do unless you understand your data and the landscape of it in the first place. Now, in the absence of an adequacy decision, which I think we've got to assume is going to be the case, if you are transferring personal data from the EU, then you are going to need to ascertain which safeguards you need to have in place. And of course, those standard contractual clauses are most likely the ones you're going to use. But obviously you need to use your data flows in order to understand whether that is the case and whether it's applicable. If you're processing both EU and UK personal data, and the ICO is currently nominated as your lead authority, then you are going to need to decide who your new lead authority is going to be and get yourself registered appropriately. And then once the transition period ends, update your privacy policy, because of course you've now got to reflect the fact that the UK now has third country status rather than obviously being a member of the European Union. I mean, that's the case with all your agreements. I mean, across everything. That's a large body of work that most organisations are having to do in order to update where necessary. And obviously ascertain if you're going to need an EU or UK representative or both. Obviously, if there's any, if you're from an organisation, if you're listening in from a US organisation, then and you're processing data on EU and UK residents, then you are going to need both. If you've not already done it, and of course, it's only where relevant, really, conduct these things called a data protection impact assessments, or DPIAs. These are they're detailed in Article 35 of the GDPR. They're used to help you to understand the risks associated with your processing, especially if that processing includes sensitive or kind of special category data, because it enables you to understand how you protect it from that risk, how you mitigate that risk. So a DPIA is not like your records processing activities, in that records processing activities is kind of defining what data you've got, where it is, and so on, whereas the DPI is specifically ascertaining what the risks involved in that processing, and therefore you can update your records processing activities accordingly in terms of lawful basis and retention policies and access and so on and so forth. So there's lots to be done in terms of that respect, especially if you are an organisation processing special category data. Then, of course, you've got ROPO, which is the records processing activities. That's defined by Article 30. As I mentioned, not all organisations are generally required to do it, but I would absolutely recommend that every organisation at least attempt to complete a records of processing activities. You can download a spreadsheet from the ICO that contains all the columns you need to kind of complete, or to at least think about. And what it does is it just gives you much better visibility and control over your data. Your ROPO will need to be provided to your representative. So if you do appoint a representative, they should, if they're doing their job properly, be asking for visibility and access to your records processing activities, because that gives them an indication of the activities that you're conducting on EU residents. So if you haven't done it because you didn't need to, then you're probably going to need to in order to do so, and therefore you are going to need to appoint a representative that maybe can help you to make sure that you've defined those appropriately. And then the last one is really amend your breach procedures and notification protocols. Obviously, if you're the size of organisation that was registered under the one-stop shop, then of course your protocols and procedures are now going to be entirely different. You're going to have one for UK reporting and one obviously for whoever your new one-stop shop is, if you've got one in the EU. So again, for the larger organisations, there's a reasonable amount of thinking and pre-planning that needs to be done in that respect.
Yeah, definitely. And I think it's also important, we've been saying it again and again, but it's important to remember that a lot of these things will need to be in place for January 2021, not something you start thinking about in 2021, right?
Exactly. I mean, the thing about a representative, I know we keep going on about representative, but it's the kind of thing where a regulator can do very simple desk-based research to find out whether you are complying with the law. They don't have to come and knock on your door and do an investigation. They just need to look at your privacy policy and see if you've nominated somebody as your representative, and then they've got basic inquiries to work out whether they're an appropriate appointment. So it's the kind of thing that they will be very easily able to do, and who knows, but if there is any residual animosity, then it may be that EU regulators might be checking up on a few UK organisations to make sure they are towing the line once we have officially closed the door.
Yeah, I wouldn't be overly surprised by that either, to be honest. Okay, so there's our checklist. Now we're going to go on to, I'm just going to talk through the pre-detect platform quickly, and then we'll get on to some questions. So essentially the pre-detect platform covers a lot of things we've been discussing. It helps you identify and analyze threats and weaknesses in your processes. It allows you to then create data protection measures for your company regarding those processes. And something that I always think is data privacy is an ongoing task. It's not a one and done. It's definitely ongoing. So the platform also allows you to monitor and ensure you have task management going so you can keep on top of all of that. And also there is the EU GDPR Representative, which is also offered by PreDetect, and we've spoken about this a lot, but we would essentially be monitoring your compliance, being a representing you in the member states, working with the supervisory authorities when necessary, receiving legal documents, retaining the records of your processing activities, and obviously we'd have a certificate proving the appointment to avoid the issues that Rob was just mentioning, as we'd be your official representative, which means we'd be mentioned in the privacy policy, for example. And here is just a large list of things that the pre-detect technology does. So here we've got things like the gap analysis, so we can find gaps in your data protection that pairs well with the risk assessment, so we can figure out how to mitigate those. And then things like TOMs, technical organizational measures, things that you can implement to ensure that your data is secure, all the way to things like the external DPO service, document automation, data breach management, etc. So it's a very holistic package there. And of course, you can book a free demo by contacting us or take advantage of a free trial to give it a go. So feel free to reach out. And now we're gonna take some questions, I think. Let me see what I've got here. So, Rob, I've got one for you. Can our DPO be the EU representative?
Generally, I would probably say no, but only if it is under certain circumstances. So basically, the European Data Protection Board they put out a clarification probably about a year ago now, actually, where they didn't rule out the ability for a DPO to be also to be the representative, but they certainly did indicate that the two roles are likely to conflict, and therefore it's important that if you're using the same organization, then there needs to be separation in terms of who is your DPO and who is your kind of nominated representative or the person within that organization. Ideally, I would spread it across. I'll be looking to spread it across multiple entities. I mean, the obvious one is, from our perspective, we have DPO Centre in the UK, and we also have DPO Centre Dublin or DPO Europe, and so you're able to create a separation between the two. But on the whole, it's either separate organisations entirely, or at least separate entities, I would say, is probably the safest way to go.
Yeah, I definitely agree with that. We've got a lot. Okay, so how can it be that the UK is adequate on the 31st of December, but not on January 1st, just the next day?
Yeah, this is a classic one, this one. Well, I mean, it all comes down to the Treaty of the European Union, and effectively, the CJEU decision is to a degree clashing with this slightly, but basically, national security remains the sole responsibility of each member state, and something like the Investigatory Powers Act in the UK, which is basically our snooping charter, is essentially ignored whilst we are a member of the EU. But of course, as soon as we come out, it has to be, or it is then taken into account, and therefore it becomes a factor in any adequacy decision. And it is essentially what the likes of Max Schrems or any other independent organisation is likely to be having taking issue with once we're out. In the same way as obviously they're essentially taking issue with FISA 702, which is the US law. So. Also, obviously, once we're out, it becomes the Supreme Court within the UK that is the highest court of the land, and therefore if you take issue with something that's going on, then you can take it obviously to court. Obviously, it won't be the ECJ anymore, which is the highest court in the land. So again, you lose your legal recourse in order to take it through. So it'll be decided by a UK court rather than an EU court. And so all of these things add up to the fact that a different decision has to be made as of the 1st of January compared to the one made or acted upon on the 31st of December.
Yeah. Okay. Another one here. We've got a scenario. So a US company which processes European residents' data and has a representative located in the UK, would they need to move their representative to another country?
Okay. So if you only if you only process data on EU residents, not UK residents, then you will need to move it, because you need an EU representative now, not someone who's based in the EU. You need someone who's based in the EU. But if you are also processing UK residents' data, then you're going to need both. So you would keep the one you've got essentially, and then enter into a new arrangement with an EU entity. And so, as I say, it's kind of EU companies, organisations need to appoint a UK rep. UK organisations need to appoint an EU rep, and non-EU UK organisations, like someone in the US, needs to appoint both.
Excellent. So there's one here that says my company has less than 350 employees. What part does not apply to me? I think this was referring to the registry of processing activity.
So if you look at Article 30, I think it's on the last line of it. It basically relates to organisations with 250 or more employees. It's about the only reference to a company size that's left in the GDPR in the final text wording, and it's just a requirement that you produce your records processing activities. But as I say, I'd be encouraging most organisations, regardless of that 250 limit, to whoever's responsible for privacy within that organisation or compliance within that organisation, I'd certainly recommend producing. Whenever we go in and do our onboarding exercise, generally is to, if it doesn't exist, is to create ROPA, and because it's the basis, along with your data map, if the two aren't necessarily combined anyway, but it is the basis of being able to deliver a privacy framework within an organisation.
Yeah, definitely. So I think the same person actually asked another question. So it's another scenario. So my company has employees in France under the UK legal entity. What are the issues I may face in this scenario?
Well, the important thing is that the EU GDPR relates to EU residents, not EU citizens. So the fact that they are resident in the EU means that you are subject to EU GDPR. So if you've got employees in France, then you are going to need to comply with EU GDPR and UK GDPR.
And I think we've got one last one here, and then we'll wrap up. So, do employees need to agree with the new privacy policy?
Well, as in confirm they've read it, as it were.
Yeah. I assume this is some kind of training related.
Ideally, all employees should be exposed to your policies and indicate that they've read and understood and happy to be abide by. It's all part of your kind of general training, but certainly whenever we do a kind of data protection awareness training within an organization, it tends to be 50% this is what data protection is all about, and 50% and these are your organization's policies and what they expect of you in order to protect data. And so the two kind of go hand in hand. So so many organizations kind of say, oh, we're GDPR compliant, we've produced a bunch of policies and we've stuck it on in a ring binder file on the shelf and never looked at it again. And obviously that's clearly not the case. You need to be ensuring that employees understand and know how to respond to it. So identifying data breaches, bring your own device policies, individuals' rights requests, like identifying data subject access requests, things like that. Your organisation, certainly of any significance, should have a policy that sets out how your organization will approach that kind of request or that kind of issue. And so when it happens, you don't have to work out, oh, now what we're going to do. We just had a breach, and now what? You've predefined what your actions are going to be within that policy, as well as who's involved and what the steps are going to be. And so obviously it's important that there is some training to distribute those decisions to everybody involved, and that would normally be, as I say, kind of delivered alongside. This is what kind of GDPR and PECA and all the other regulations are all about. This is what they say, article this, that, and the other. But what's really important is how that translates to how your organisation expects people to process data, and therefore it should be an integral part of any training that you do.
Yeah, I definitely agree. I think the answer to the question would be yes, they definitely should, and that should definitely be part of the training that the company offers generally in terms of GDPR. It's actually something that Predetect has been doing recently, and I think it's good for every company to ensure they're really up to date, because it's not just making sure that the upper management understands the data privacy and what they can and can't do, right? It needs to be a whole top-down, bottom-up organizational understanding. Definitely.
If you look at what the ICO published in terms of how it came to its decision in terms of the fine for both BA and Marriott, they list a whole bunch of failures effectively that the organisation was subjected to. But at the top of that list is always the training and the policies and the implementation of those policies. In the first thing they look for is, what's your policy? So what did you say you were going to do in this situation? And then look at what actually happened in that situation. And obviously that's where the failure occurred. And therefore they hadn't necessarily implemented appropriate organisation and technical measures to mitigate the potential for that risk. I mean, the important thing is that the ICO kind of doesn't fine people. It's a bit odd thing to say. They don't fine people or organisations for the breach. What they fine people for is that the breach was allowed to occur. So, if you have a breach, that these things happen, not great. But actually, what they're looking for is, did you take the appropriate organisational and technical measures that could have avoided having that breach in the first place? And if it's found that you didn't, and that led to a breach, then that's where the penalties will get calculated. And the ICO put out a piece a couple of weeks ago, literally on how they go about calculating the penalties that they're working on at the moment, and things like implementing those policies and procedures is right at the top of that list.
Yeah, definitely. So I think that's the end of our questions. Did you have any more words, Rob? Just to wrap up, or?
I guess the only thing I'd really say is kind of TikTok 7 weeks ago. If you haven't already, then kind of really start to take a look at your Brexit planning from a data protection perspective. For organisations of any significance, it's not a one-day exercise. There is a lot of understanding that needs to be gained, as well as change that needs to be implemented, and of course that is always the one that takes time. So if you haven't already, pick up the phone to somebody and get someone to come get some help, and help yourself to understand what the steps are, and get yourself ready and get everything in place, ready to go, because as I say, some of these things will be kind of desk-based research for regulators come 1st of January.
Definitely. Okay, well, I think that just about finishes here. So I'd like to thank you for joining me, Rob. This has been great. It's been very informative. And if anyone who's watching has any doubts, there's the email address there. You can shoot an email if there's more complicated questions or anything like that. And we'll see you next time. I think we're wrapped up now.
Thanks very much. Take care.
Thank you.